constructive fraud.
Okay.
When the fraud is built into the system.
Right.
Constructive fraud. Okay? Now, the really cool thing, the thing is, if you could ever prove constructive fraud, there's no statute of limitations on constructive fraud. Okay? When there's a fraud by a man or a woman or somebody who's done something to you, you've got, even in their statutory rules, you've got a time limit in order that you can go back and defeat them. In their own rules, constructive fraud may be exposed anytime. If I wanted to prove constructive fraud by the Constitution of the United States, I could do it today, okay? If I could prove that constructive fraud, and there's no statute, I can do it today. So if somebody has committed fraud on you in a constructive fraud kind of a way, while they may or may not be personally liable for it, the system is liable for it, and it vacates everything and everyone that was ever ruled against by virtue of that particular error in system. Okay? So the possibility exists if you could prove constructive fraud. And this is what they do as a matter of course. And eventually, if you win your case, as you probably will, and go back and recruit 1,000, 10,000, 100,000 other Canadians to come and say, you know, we got pooped on in the same way, you could actually come up with a case that could prove constructive fraud and overturn and vacate all of those judgments that were ever made by virtue of that particular operation.
Okay, so let me stop you right there, Greg. Greg, stop. Because like I said, I could actually tell you a case where this is a true case. Believe it or not, it's going to sound goofy, but you got to be careful when you use the fraud, like constructive fraud or fraud in the inducement or fraud in the factum. There's an actual case. I'm telling you, man, it's called Burrow versus the Superior Court, okay? This is a funny case. This only happened in 1985. So we'll see if you can watch the silliness of this. The doctor, Dr. Stevens, called up the victim, okay? And he's saying that he was Dr. Stevens from the hospital and that the victim had a life-threatening disease. So he told her, he presented her, believe it or not, this is true. This ain't a joke, with two options. The first option was to have a painful surgery costing the victim $9,000. You can Google this. It's BORO versus Superior Court, 1985. Two options he gave her. He said you could have a painful surgery that cost you $9,000, or she could have sex with him, and it only cost $1,000. Okay? So the victim had intercourse with the defendant, believing at the time that her life was threatened, and that was the only choice she had to cure this horrible disease. Okay? This is true. The victim, upon learning the truth, brought the charges against the defendant for rape. Okay? The court held that this was fraud in the factum, and therefore there was no rape. Okay? It was fraud in the inducement, because the deception related not to the thing done, the sexual intercourse, but merely of some collateral matter, like the cure of a life-threatening disease. So that's what he really did. So you got to be careful when you use fraud in the inducement or fraud in the factum. Like when you say fraud in the factum is more misrepresentation. It causes somebody to do something without realizing the real risk, the duties, or the obligations. It's like saying that let's see, John tells it, let's say some guy tells his mom that he's taking a college course on handwriting analysis, and for his homework he needs her to read and sign a pretend deed. So his mom signs like this deed, believing that, John said he's just trying to work on his lawyer skills. And, John really has his mom sign this blank piece of paper or this deed, and then he fills in the rest. That's fraud in the factum. Okay? That's just flat-out fraud. He just had his mom say, I'm just doing some handwriting analysis skills. Can you sign this blank piece of paper? So she signs a blank piece of paper, and he writes, you just transferred all your property over to me. Okay, that's fraud in the factum. See, fraud in the inducement is just a trick to try to cause somebody to do something to take away your real property away from you. Okay, it's right. Fraud. Right.
And fraud in the inducement and fraud in the factum on the statutory side both have a time limit in which you can prosecute.
To a point. But when you claim that you're a man, you have no statute of limitations. Anybody doing you wrong, whether it's
no, but like we were saying earlier, sometimes we as men can move freely in any jurisdiction we want. If we're going to go and operate in that jurisdiction, there's a time limit. There's a statutory limit to prosecution. And
well,
the point that I was making was that fraud in the system. If the system itself is fraud, there is no statutory limitation.
What I'm saying, that was a great example that you gave us, that it was fraud in the system. But if she signs a contract and she works with these people, then there's going to be a statute of limitations in what she can and cannot do, because somewhere she signed a contract. So they will have latches on that, built into that contract, what the parties can and cannot do, what one side is liable for, what the other side is not liable for. But as long as she stays as a man or a woman and does not bind herself with this intercourse with this monster, because she's afraid of some crazy home disease she's going to get, she stays away from it. If this monster ever tries to claim that we had an agreement, she knew all along, and she's bound by these statutes of limitations. No, she's not, because she never had a contract. She never talked to these people. Anytime these people looked at her in court, she was like looking at ceiling tiles, because she's like, what? Are you talking to me? You got a claim against me? Is there a claim before this court? Yes or no? I haven't seen one yet. Well, I got all those people. Man, is that a claim? Well, no, it's a claim. I only answer the claims. I'm a man. I'm a woman. I only answer claims. I don't answer that. Anything else? Sir, Mr. Guy in a black robe, is that true? Does man only have to answer to a claim? Is there a claim verifiable before this court? Yes or no? No. Then what the hell are we doing here? Well, they want to just talk jibber-jabber about the code and how you're never going to get your kids. Okay, great. Is that based upon a verifiable claim? Is this not a common law proceeding? No, this is an administrative code proceeding. So, you think I'm some sort of code decipherer? You think I'm going to sit here and try to get some jibber-jabber and try to interpret code? You think I should get a code interpreter here called a lawyer and attorney to decipher your jibber-jabber for me? No. I don't trust any of it, because the first duty of that attorney or that lawyer is to this court, not to me. It's to the court and the rules established under those codes. His first duty isn't to the rules of common law to protect his client. His first duty is to protect the code. The rules of the law that are before this court, his first duty is to the law. The law before the court is the rules established by the other side. Whatever the other side established as the rules of the court, as the law of this court, that's his first duty to do. So if I try to tell my attorney to say this, object to this, he's going to tell me, shut up. They're in compliance with the rules of the court. You say, no, I got these rights. Not in this proceeding, you don't. You're the defendant. You didn't establish the rules. You don't have those rights. You will have them in common law, but you don't have them here. Shut up and sit down and stop. And she's like, but I have a constitution. You ain't got boo. I got the Great Charter of 1982. You ain't got squat. Sit down and shut up. The terms are written in the contract. There is no contract between me and the other side. What? What do you mean there's no contract? There's no contract. Tell them to bring the contract forward. Oh, they definitely have to have a contract. They have something that binds you to that. Oh, I'm telling you, Judge, they don't. Tell them to bring it forward. Tell them to bring a law before the court. And so the judge says, is that true? Is there any contract? Is there any law before this court? And they say, well, no, sir. It's like, oh, my God. Do you realize what you're doing to these people? The other side knows exactly what they're doing to you. If there's no contract before the court, if there's no law before the court, they're filing a false claim. It's frivolous. It's a perjury. There's all kinds of words for that. For moving barratry. It's ridiculous what they're doing. Because, like I said, the very simple claim that I had Jesse do was basically saying, I, and then her name, and it says, claim the wrongdoer's trespass against my property. See Exhibit A. And Exhibit A was the property. Number two was there's no law that exists which binds I to the wrongdoers. There you go. Since there's no law that exists which binds I to the wrongdoers, there you go. Is there any law that has the jurisdiction and control over me? Is there a contract? Is there something that binds me to the wrongdoers? No, I have no idea who these freaking people are. I've never seen them before in my life. They just manifested themselves in front of me one day, and I have no freaking clue what they're doing in my life, but I want them gone. Okay, that's number two. Number three, I require the delivery of all said property to be under my jurisdiction no later than April 18th, 2013. And number four was I will place a charge of $1,000 per day per said trespasser and said agency for any failure in the restoration of property on said date. Number five, if the placement of all said property does occur on and or before April 18th, I will forgive those who trespass of their debt as I would wish others to forgive me of my trespasses or my debts. That was the whole lawsuit. That's all you need for a lawsuit. Nothing else.